in having this whole discourse, it's important that we situate it in context. And although I am at the presidency, I haven't seen a copy of the petition. I haven't cited copies of all the 5 petitions.
So the Constitutional and Legal Affairs Committee, yes.
Okay, so I haven't cited the petition. At the presidency, I can tell you on authority that if they say state secret, the petition was treated as if it was a state secret. And so, although the petition was received long ago, some as far back as February, some as far back as 17th March, nobody and none of us even saw the contents of the petition. It is only curious that the copies of the petitions, whether they are true or false, started flying around after the Chief Justice was given her copies. And so you can tell that if there is any leakage, certainly it would not be from the presidency. And that is what, and it in itself calls into question how sometimes these processes are done. But be that as it may, it is also important to establish that we can talk about this whole processes on the removal of the Chief Justice without knowing about the contents of the petition. In fact, I heard the former Deputy Attorney General, Dinah Dapa, or whatever, I can't get her name right.
Dinah
Dapa, copiously referring to the content of the petition. And I've heard some of the lawyers in the NPP referring to the content of the petition and the responses. And maybe they should be assisting us with where they got copies of the petition. Because if I, as a person who speaks for government, I can tell you on authority, the copies of the petition did not emanate and could not reasonably have emanated from the presidency.
How do you know that?
Because I work at the presidency. I am at the president's secretariat.
You don't think that it's possible for a leakage?
It's not possible because of how it was treated. And it is not possible because when the president received the petition, for weeks, nobody knew about a certain petition until after she was given copies. And so, why would the president want to leak a petition that they've had for more than a month? So that point has been made. But let me say that I hear the people who say they are probably concerned about the independence of the judiciary or what many may perceive as interference with the judiciary. And let me say to the people of Ghana and allay their fears that as we speak today, the independence of the judiciary is intact. We have an acting Chief Justice in the person of Justice Bafo-Boni. As I speak today, my colleague lawyers are in court, moving their motions, doing their cross-examination, and nothing has changed. The Chief Justice is not synonymous to the judiciary. And the earlier she accepts that she is not an epitome of the judiciary, and that she's only the head of the judiciary and subject to the laws like any other person in Ghana, the better for her. It is also important to establish this fact that the suspension of the Chief Justice is done by a man called President John Dramani Mahama, who has a track record of having zero tolerance to certain things in public services. We are talking about a man who, when he had opportunity to be vice president and president between 2012 and 2016, did not pack the judiciary with judges. The law says that the president on the advice of the Judicial Council, in consultation with the Council of State, can appoint Supreme Court judges. At the time President Mahama was president, the 1992 Constitution was still in effect, and he did not abuse that. And so we are having to discuss this matter within the context of a man who had an opportunity and never packed the courts with NDC judges like we have experienced in the past 8 years, when Nanado appointed 55 justices. 55, unprecedented. Not even MPPs could afford that.
How did you end up tagging judges who have been appointed as
Justice Dawu was not a parliamentary candidate of the MPP, and so many others. I mean, this is public knowledge.
Okay.
Where
so based on that.
Oh yes. We are also talking about a president who does not call judges, or does not have an attorney general that calls judges to decide cases in their favor, or can't tell the people that we will overturn this case and in 3 days the case is overturned. We are talking about a president with integrity who has allowed the judiciary to do, in fact, many problems that our own members have with us is because they think that we have not interfered with the judiciary. We are also talking about a president who has acted on this Article 146 that has become so famous in recent times. In the case of Ms. Lamte, when the MPP's Richard Nyama petitioned the president and said that Madame Vivian Loretta Lamte ought to be removed or suspended pending investigation. Do you know that Madame Vivian was the president's own appointee? What did President Mahama do? He removed in accordance with law. We are talking about a man who, under his own government, he finds that his appointees have done wrong. And in the case of Victoria Hammer, which I maintain did not even do wrong, but for the optics, removed her. Abu Gapele, I say this in the most painful manner, was prosecuted by his own government. And so this is a track record of the man we are talking about. Now, having established that track record, then you place it into context to see whether the MPP really has a point. Because what the MPP is doing is inviting all of us to solve a legal problem with a political lens. This is a legal problem that we have to discuss within the context of law, and they are just shifting us into NDC MPP, calling on Christian mothers, Muslim women, and all other people to come up and talk. In all these discussions, it is instructive to establish that the MPP lawyers, including Godfrey Dame, has not been able to point to one single law which has been breached by the president. He has not even been able to point to a single convention that in the past it was done this way, and we think that it was so well done this way that the president, in good conscience, or helping the citizen to establish what we call convention, should even go by that way. And so the point has to be made forcefully that President Mahama has done absolutely nothing wrong. Why do I say that? The president receives a petition, 3 different petitions at first. The Constitution says that the president has the duty, a constitutional duty for that matter, to refer that petition to the Council of State. The question we should be asking is whether or not those 3 petitions were referred to the Council of State in accordance with law. The answer is yes. The question is whether or not the law imposed a duty on the president to give copies of the said petition to the Chief Justice. The answer is no. But you know what the Chief Justice did? You see, she will have a day before the 5-member committee. But the Chief Justice, believing that she was law unto herself, and that her understanding and interpretation of law in itself would have to be a procedure, then wrote to the president, obviously copying people who were not even relevant to the discussion, and asking that, you know what, Mr. President, as Chief Justice, I have had the opportunity to preside over 5 similar petitions requesting for the removal of Superior Court judges. And what I did in my case was that I gave copies of the petition to these judges. They responded before I made a determination of whether or not there is a prima facie case to answer. And so by reason of that, give me copies of the petition, and in 7 days I will respond. President Mahama had every right, howsoever described, at that stage not to even respond to the Chief Justice, because he was not mandated in law at that stage to give her.
But you know that has been contested by your colleague lawyers.
Which one?
I know Vincent went to court. Yes.
Please don't interrupt my.
No, you
discussion.
can't tell me. No, you can't tell me not to do that.
And you know,
you can't tell me not to do that.
And this point also brings me,
because that's how.
And maybe
you guys, you learned colleagues, play with the law.
You see, and at this
he
point,
said it's legal to provide the Chief Justice copies,
at this point,
based on which he went to court, that it is not fair to have petitions against her and she doesn't know the content of the petition she's coming to respond to.
I will address that, but at this point, I think that if the Chief Justice is watching me, I think she has to change her lawyers, if she has any. Because it appears to me that from the approach she's adopting, she's getting wrong counsel. And I'm hoping that Godfrey Dame is not the lawyer. I'm hoping. Or maybe Godfrey Dame will call committee members in line with his unethical practices as we have known him to be. But the point I'm making is that, although President Mahama was not obligated to, he obliged the Chief Justice. And you know what he did? He did not just give her the 7 days. He even magnanimously added 3 extra days and gave her 10 days and said that you can respond if you so wish to this petition. The Chief Justice responded. And then again, the merit or the content of her response or responses to all those 3 petitions are not material to this discussion at all. After her response, the Council of State found that the prima facie case has been established against her. And so, the President, again, in accordance with Constitution, says that may suspend the Chief Justice. And the President carried out the constitutional obligation. What else are people expecting President Mahama to do? What else? And what really is the fault of the President in this thing? Is it the MPP's suggestion that where the Council of States has established a prima facie case against the Chief Justice, President Mahama should say that in spite of your finding as a Council of State, I have, as a President, exercising whether quasi-judicial discretion, come to a conclusion that there is no case for her to answer. Is that the understanding of the law in recent times? So the point has to be made that President Mahama did absolutely nothing wrong. He acted in accordance with the constitutional provisions as contained in Article 146 and in the Ejechun decision. So no wrong has been established. Now what the MPP is seeking to do, which sometimes I even feel sad and is not working, is calling on women to speak up. Please, Madame Vivian Lamte, I want to ask respectfully, was she a hermaphrodite? Charlotte Osei, was she a man? Or the MPP, and in any case, the Chief Justice, is she a member of the MPP? The MPP saw nothing wrong. You know, in even discussing this, we want to compare it to the procedural treatment that both parties are even receiving. In the case of the Chief Justice, she has been given copies of the petition. In fact, the last two that also came, she has been given copies. So she has copies of all 5 petitions. In the case of Madame Charlotte Osei, I have here in my hands a letter that Madame Charlotte Osei wrote to the then Chief Justice, Sophia Ekufu, asking that even before the committee will hear me out on my guilt or otherwise, I pray that I should be furnished with copies of the said petition and the names of the petitioners. The presidency did not give. The then Chief Justice did not give.
Oh, she requested at the time?
She requested for it. She was not given. And all of a sudden, the apostles of rule of law.
That's because there's no legal obligation. Then you can use that as a, a case.
If there was no legal obligation, but there was even an ethical obligation. That, you know, in the case, the Chief Justice said, we want to hear you. It is different if the Chief Justice takes the opinion that at the stage of determining this case, I don't need to listen to you first. Maybe you will have your day at the committee level. Then we can say that it is her discretion. We can challenge whether she exercised the right discretion or not. But this time, you wrote to her that a petition has been brought against you and I'm here to determine a prima facie. So bring me your responses. Responses without copies of the petition. She was only told, perhaps via hearsay.
So when she said, can I have a copy of the petition, she had been requested to bring her responses without having copies.
The Chief Justice then, Sophia Ekufu, wrote to her that there is a petition against you and the effect of the petition is that you've done A, B, C, D. So respond so that I can make a determination. Then she writes back and says,
can I have copies?
Before I respond to you, can I have copies? And then they said she is unable to give her copies and that she has made a determination and has referred the matter to the committee to investigate her, so she should go back there. Where were the apostles of the rule of law? So this is a marked departure from what President Mahama has done. President Mahama actually gave the
I'm a little interested into the details. So did she get a chance to even do any response at all?
At the prima facie level, no. It was at the main committee level.
Oh, okay.
And Afenyo Markin and the Muslim women and Christian mothers and all the Ghanaian women they were calling on did not know that Madame Charlotte Osei also had breast and she had blood flowing through her, so she was a woman. And that as a woman, she also had been heard. And all of a sudden, it is only Madame Isaba. I actually like the Araba Isaba name a lot. Madame Araba Isaba is the only woman. Thankfully, even the Christian mothers or whatever have come out to say they haven't made these responses. And so there is fundamentally nothing wrong. Now, let me come to the Ghana Bar Association. That I am a member of the Ghana Bar Association.
You want to be careful.
I can never be careful. I don't know why people fear the Ghana Bar Association.
No,
I am a member.
I'm saying so because you're a member.
So what?
I mean,
what?
I know the history
I am a
of
member,
comments you've made.
I am a member of the Ghana Bar Association. I mean, nobody can intimidate me, not even the Ghana Bar. So they know me. We all meet in court. We know ourselves. We are not afraid of ourselves. Maybe non-lawyers can fear Ghana Bar Association, but not me as a member of the association. You see, the Ghana Bar Association started on a very good note. And then I can tell you this on authority, on the MPP lawyers platform, Godfrey Dame and the Deputy Attorney General started rallying lawyers behind. In fact, they were practically taking register, asking MPP lawyers to be present at the mid-year conference that the Ghana Bar Association wanted to hold so that they come to put pressure on President Mahama.
Sorry, can you?
Yes.
What did you say?
I'm saying that the MPP, NDC lawyers, we have our platform. MPP lawyers also have their WhatsApp platform. After the Ghana Bar Association released a statement, a written statement for that matter, saying that President Mahama has done nothing, and that they, as Ghana Bar Association, they were unable to even comment on the matter because the matter was before a court. And so they urged all parties to go in accordance with law. Then I realized that the MPP lawyers were not happy because this is not the Ghana Bar Association they know. So quickly, they held a mid-year conference and said that, oh, they are making a resolution and asking President Mahama to revoke the suspension. And also the second one is that the proceedings should not be held in camera. I think that Madam Efua-Gate doesn't like the Chief Justice. I think some way, unless she convinced me she likes the Chief Justice, because you cannot on one breath say that the matter is before court, so you cannot speak to it. And another breath, say that the president should suspend and say that things should be held in camera. You see, the image of the Chief Justice, if the proceedings were held in camera, would be so battered that even for the collective image of the judiciary, it would not be good. And so there are even judicial decisions where Supreme Court judges have said that there is a policy rationale behind why certain proceedings ought to be held in camera. So if this morning you wake up and you see the Ghana Bar Association says that we should hold proceedings in the public, then you can tell that Madame Efua-Gate doesn't like. But you see, the Ghana Bar Association, what is instructive is that they were not able to pinpoint one thing, one single thing that President Mahama has done wrong. They were not able to say that the rules of natural justice have been breached. They were not able to say that this is an interpretation of the law that we should not have done. They were not able to say it.
No, it's not that they were not able to say it. That's because there isn't any to say.
Yes.
Okay.
But that's the point. So if there was anything to say, trust that an Efua-Gate is the wife of Mr. Joe Gate, who is an MPP person. I'm sure they may even have those discussions in the room before coming out. There is nothing wrong with what has been done. The lesson here for all of us in concluding is that as public servants, or when you have an opportunity to serve the nation, you don't use those opportunities to enrich yourself. You don't use those opportunities to satisfy your ego. You don't use those opportunities to satisfy a political party that you so believe. That at all times, to quote the Chief Justice, the law ought to be the law. As we speak, proceedings from the petition to the referral to the Council of State, to the suspension or the determination of the prima facie case before the suspension, are all in accordance with law. And the law is the law, unless anybody can convince us otherwise. Ghanaians should not fall for any political party that wants to make this an MPP NDC matter, because the Chief Justice is not a member of the MPP. The Chief Justice will have an opportunity and the right to counsel of her choice. I only pray that she will not choose Godfrey Dame, because maybe Godfrey Dame will not have the opportunity to call judges or the Supreme Court judges on her behalf. Maybe our jurisprudence is changing, and the law certainly will be celebrated like the judges of old, as we had Justice Sowa and Justice Taylor and Justice Datiba and many justices that we have celebrated.
Okay.
So I want to conclude and say that the laws in Ghana would work, and they are working.
Okay.
If we want to have a broader conversation about constitutional review, we need to have, and Annie, let me conclude, let me say this. If you look at the procedure in Article 146 for removing a Supreme Court judge, it is primarily different from in removing a Chief Justice. In fact, if you look at the report of the Consultative Assembly in drafting the Constitution, although they say that in both cases, when it comes to the superior court judge, like a Supreme Court judge, you ought to establish that prima facie case. It was actually deliberately removed from the Constitution. In the case of Petition, read it into it. Whatever it is, we are saying that President Mahama has acted in accordance with law. We salute him as a person who respects the tenets of the Constitution, and we say that the Chief Justice will have her day. Right, at the end of the day, if she has not done anything, she can come back to being a Chief Justice.
But you don't have a problem with the public hearing they are calling for.
But they know that the law says that the proceedings will be held in camera. If Agatha knows better than me,
yes, but
that you can only amend the provision.
No, but at the same time, she's established reasons why she thinks that if
reasons,
it's held in public, it won't kill an ant.
She cannot be wiser than the framers of the Constitution.
Okay,